I have nobody. I can't even use the phone. I can't talk to anybody. Nobody. I have no way to contact anybody. I'm indigent. Your Honor, please, I'm begging you to just let me. I'm a sovereign citizen, Your Honor. I trust my opinion.
I heard you. And I can't save you from yourself, but I'm just saying that.
Yes, but Matthew Davis stole my phone. So I have to get out and get a new phone, but yes, I can receive them on that phone.
And that's the victim in the protection order in Superior Court case, Your Honor.
What's your name up there?
Alicia Martini. Your Honor, on 6/6 of this year.
Wait, ma'am, just give me a minute, please, ma'am. So on the new case, Ms. Moore, 25 DV 1023, she's here on a warrant return on that case. She's held on bail in the other case. This is the arraignment on the protection order case. But it looks like they've already set confirmation and trial dates without her being arraigned. How did that happen?
I have no information, Your Honor. Ms. Martini has declined counsel. She wishes.
Okay, so hang on just a minute. Okay, so ma'am, your name is Alicia Martini?
Yes, sir.
And then you're here on a couple of things. You have that are unrelated. You have some driving offense, so driving with license suspended in the 3rd degree, as well as operating a motor vehicle with ignition interlock, without an ignition interlock when it's previously ordered. And then
my original DUI was thrown out.
Just let me, ma'am, let me finish. I'm just telling you what your charges are now. I don't know about prior charges. That's a charge. You may have a defense to it. I'm just saying that's what you're charged with right now. You're also charged with one count of violation of a protection order. And then you haven't been arraigned on that. We're gonna do that at some point today. So on the violation of a no contact order, and again, these are just allegations, that's a gross misdemeanor that carries with it a maximum of 364 days in jail and a $5,000 fine. So anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney. If you can't afford an attorney, do you understand all those rights?
Yes, Your Honor.
Okay, I want to go back to that first right, and that's the right to an attorney. That's an important, and if you can't afford one, as I said, I can appoint one to represent you. And I'm fully prepared to appoint an attorney to represent you in this case that you're in front of me here right now. And most people, pretty much everyone else, when they get the opportunity to have an attorney appointed to represent them, they jump at that chance. But I'm told that you're not as inclined to take advantage of that offer.
Yeah, I'm a sovereign citizen, Your Honor.
Okay. You know, sovereign citizens can take advantage of an attorney as well.
It's okay, I'm pro se.
So, ma'am, you have you ever represented yourself before?
Yes.
Okay. Have you ever gone through trial, jury trial?
No, I never had to.
Okay. Have you ever been to law school?
Nope, never had to. They got dropped.
And you're not a lawyer?
Nope.
Okay. And so you understand. Okay, but I'm not sure about these cases, but you understand the prosecuting.
These charges were already NFC'd last time I was here in jail.
Okay, so ma'am, you understand the prosecutor in these cases are lawyers. They've been to law school. They understand the rules of evidence, rules of criminal procedures, things you may not be trained on. So you're operating at a pretty serious disadvantage. Do you understand that?
Yes, Your Honor.
And knowing all that, you still wish to represent yourself at this time?
Of course.
Okay. You actually have 3 cases. One was just added. That's why there was a little bit of a confusion. You're charged with, on the case 25 DV 1017. Okay. So, ma'am, you have a court date set on the DWLS and the operation of motor vehicle without an ignition interlock. You have trial confirmation on January 7th. You have trials on January 12th and 13th on the assault in the 4th degree. On the the new charge, which is protection order violation. A plea of not guilty will be entered. This matter will get set for a pretrial. We can do that also on, and you're not being held on this is a warrant return on the new charge, the protection order violation. There's $5,000 bond on that. I don't bail on that, or warrants. I'm going to hear from the state on conditions of release on that, and then I'll hear from, I'll come back to you, ma'am.
Okay.
Mr. Libby?
Your Honor, no objection to leaving the conditions that were previously imposed as is. That's the $5,000 bail that was set on December 1st for this new matter, 1023, as well as the previous conditions that were imposed at the prelim all the way back in October 27th.
Which are no criminal law violations, comply with the no contact order.
Yes, Your Honor. Sorry. Yes.
On the case ending in 10/17, there's going to be no changes in conditions of release on the case. And then your next court date is January 7th, I think. On the case with the operating motor vehicle without an ignition interlock and the driving with license suspended in the third, that'll no change in those conditions also. There'll be this $1,000 bail set in that case. In the new case where we are setting where you're getting arraigned on, which is case ending in 10/23. I'm not going to hold you on that case either. All prior conditions remain, which are don't have any criminal law violations, don't possess a firearm or other deadly weapon, comply with any existing no contact order. We'll set a pretrial.
178.
We'll do it earlier than that and back these up on the other one. We'll set a pretrial on Wednesday, December 17th. We'll set it right on the 1:30 calendar. Or actually, no, we'll set it earlier than that in case she makes bail. That's only $1,000 at 10 a.m. And that'll be it for today here. And then you can be taken back. Do you understand all that, ma'am? Yes?
Can I please fight for my own bail?
Can you what?
Right. Fight for a PR. That's my right.
It is. And that was.
And you said you were going to hear from me and you didn't.
Okay. I could hear from you now because I'm not holding you on the new charge. You're only being charged on bail on one case. And that was the case that was decided by Commissioner Wool a day or two ago. So if you're asking me to reconsider or redo what he did, yes, you can do that.
Yes, Your Honor, please. Okay, so I've been held for a substantial amount of jail time on both of these charges now. They're both misdemeanors. Neither one is violent. The driving charge, like I said, I'm a sovereign citizen, so I have the right to travel. And also on 6/6/2025, that charge was vacated due to speedy trial rights violated because from 2019 to 2020, I never had a court date set because of COVID. So they vacated that charge on 6/6 of this year. I got a status case report from the Thurston County Clerk on 6/6 stating that case was terminated.
Ma'am, I don't see that case was dismissed. I'm looking through the docket now. Looks like you had an attorney for a while on this case.
On 6/6 of this year, there was a case status report from the Thurston County Clerk stating that it was terminated or vacated. Terminated. Case terminated due to speedy trial rights because if you notice from 2019 to somewhere late in 2020, there was never a court date set because of COVID.
Okay. So hang on just a minute, ma'am. Mr. Libby, you wanted to say something?
So I'm seeing there was a hearing on
6/6.
June 6/6. I was present for that. I believe the state asked for a motion to continue. Mr. Pazderka objected. Trial was reset the hearings were reset 1 week, and we entered an excluded period.
Right. And then she didn't appear for trial. And a warrant was issued on 6/23.
Yes, I'm seeing that as well. Yes.
So, ma'am, I'm not reading the docket the same way that you are.
Okay, maybe the date that I have is wrong, but it said case terminated. I got a case status report sometime in June, I believe.
Okay, and what my reading of the docket says, you were not here for confirmation on June 6th. The trial was going to be set for June 23rd. You were supposed to be there on June 23rd. You did not appear, and then a warrant was issued at that time. And I don't see anything. One thing that may have been canceled was your trial date was canceled once you missed your court date for
No,
the
it
warrant.
literally
If the
said
case was
case
never met,
terminated.
please don't. Okay. I don't see that. And I don't see that in the docket that I'm looking at.
Your Honor.
And so,
No, I'm
If I
asking
may.
to be released so I can get that information for you.
No, nothing, Your Honor. I'm just trying to clarify stuff.
we'll go ahead if you can. That would be great.
There doesn't, Mr.
If there's ever a case in need of clarification, this would be it.
There does appear to be a 2017 Superior Court matter that was vacated. I believe it was a blank case.
I can help Your Honor.
Oh, I see.
Case 17, TAC 1, TAC 0, 43380, TAC 0. I wonder if Miss Martini is maybe getting that case mixed up. That was a blank
No,
case.
no, I'm not.
Okay. So, ma'am,
It was case terminated, not vacated. Yes, I had a case vacated as well from the last time I was in prison, but this case was terminated. I'm just asking that I please be PR'd. These are not violent crimes. The victim was not the reporting party of the no contact order violation. I don't have any way to post bail or any way to even contact anybody right now, as the victim was my only person that I had in life, pretty much. So I'm just asking that I be please PR'd.
what I'm going to do here for today, ma'am, I'm going to set the protection order. The new protection order will be a pretrial on 10 a.m. on December 17th. And then on the, what I will do is this, ma'am. I'll set this back on the calendar for only being held in bail on one case, and that's the DWLS third and the ignition interlock. That's probably been around for quite some time, but now that you've given notice to the state of your wish to have bail reviewed, we'll set this over 24 hours tomorrow, and then we can check in to see whether this thing has actually been vacated or dismissed or what have you. And then we can reconvene tomorrow for a bail hearing on the DWLS in the third case. And then the other can be backed up to it. All right? Now,
Your Honor, one more thing. So is the defendant not being held on that new charge, that violation of a protection order? There was bail imposed. Is that being?
No, that was a warrant was issued in the amount of $5,000. She was picked up on the warrant. Now the warrant's been served. So now we go forward. Then I make a decision as to whether set bail or something like that. That's my reading of the docket.
My reading of the docket, Your Honor, is that there was a warrant FTA at December 1st, and Commissioner Wool imposed $5,000 bail on that new protection order violation.
Oh, you did see? Yeah, I did see. I see that now. You know why it wasn't arraigned on that date?
I don't have any other notes, Your Honor, other than bail's agreement was just set for today. I don't know why it was set for today.
I don't either. And that was that was Monday?
Yes.
We'll just put all these on tomorrow. Do all these on tomorrow for conditions of release. Set all that. We've taken way too much time on this right now. So, ma'am, you could have conditions of release addressed on all these cases tomorrow at 1:30.
Okay.
And between now and then, I'd really think about your decision not to take advantage of an attorney. I think you're doing yourself a real disservice, if you want my frank opinion.
I'm a sovereign citizen, Your Honor. I trust
I
my
heard
opinion.
I heard you. And I can't save you from yourself, but I'm just saying that. Well, I'm just saying. So we'll all reconvene tomorrow to address conditions of release on all of these, so we can get all this sorted out. And you can be taken back. And yeah, the 5,000 will remain.
Good afternoon.
Good afternoon.
And your name?
Alicia Martini.
All right. And Ms. Martini, you are proceeding pro se, is that right?
Yes, sir.
Is that still your wish to move forward without an attorney?
Yes, sir.
All right. And I know you've had, I can just see from the docket notes on your cases, you've recently sort of gone through the colloquy with a judge about your decision to move forward without an attorney recently. I just want to make sure that's, you have the right to an attorney. if you wish. And I know a judge has already walked you through that. I just want to make sure that's still your decision.
Yes.
Okay. All right. And you were here yesterday, is that right?
Yes.
Okay. And correct me if I'm wrong here, but I'm going to kind of summarize where I think we're at. So this is a review hearing for bail on 2 of the 3 matters. One is a protection order violation. Bail was set at the amount of $5,000. The other is driving with a suspended license 3rd degree and driving without an ignition interlock device. For that case, bail is set at $1,000, and you are not being held on the assault 4th degree domestic violence case. Is that your understanding? Yesterday was the arraignment on the protection order violation case, and today was just to address bail. Is that right?
Yes, sir. Yes, sir.
All right. Okay. Well, so a change in release conditions does require new information, a change of circumstances, or sort of similar good cause. A judge has previously imposed those bail amounts. I'll let the prosecutor also weigh in, but I'll start with you, ma'am. What information can you give me about why a reduction in bail or personal recognizance release is appropriate here?
Can I have a breakout room with the prosecutor, please?
Well, I suppose if you're not represented by counsel, is that something that's up to you?
I'm not the attorney assigned to this case. I'm willing to speak with the defendant, but I don't know how much good could come of it. I'll just be quite honest.
Yeah, I mean, ma'am, one of the benefits of having an attorney is they're able to have those conversations. Mr. Libby here is assigned the jail calendar today, but he's not the prosecutor on your case. So it's unlikely that he'll be able to make any substantive decisions other than asking that, dates remain set.
It's okay.
Are you still wanting to speak with him? It's up to you.
I mean, yeah.
Okay. Yeah, so we can set up a breakout room. I'll take the private case while that's.
Your Honor, actually, I've spoken with Ms. Pritikin just now, who's the assigned DPA for, I believe, the 2 DV cases of the defendants. She's willing to speak with her right now. I think that might be a more productive use of time, actually.
Okay. All right. I think in order for that to happen, you said that was Ms. Pritikin.
Nicole Pritikin, yes, Your Honor.
I think she would have to sign into Zoom and then get a breakout room. All right. So, Ms. Martini, the assigned prosecutor on your case, someone named Nicole Pritikin, she is going to be signing into the Zoom hearing here, and then we'll put you in a breakout room together. All right, Ms. Martini. So you've had a chance to speak with Ms. Pritikin. So I'll let Ms. Pritikin, anything to add?
Good afternoon, Your Honor. Ms. Martini was asking for a change in her release conditions. At this time, the state is not able to do that. I would need to review the cases. I think she's currently also being held on Superior Court charges.
Not. I was PR'd on everything else. This is the only cases that I'm being held on.
In any case, I can't, in the 2 seconds that we talked, I didn't have time to review the case and determine if there's grounds to change the conditions of release and the state's recommendations. I don't know if Your Honor wants to see if there's any changing conditions. From what she told me, she has been incarcerated for about a week.
Just this time.
I
Okay.
don't
All
know
right.
that we're any further.
All right. Thanks, Ms. Pritikin. So, Ms. Martini, yeah, I also saw that I don't believe you're being held by Superior Court. But I think, and I don't want to speak for the other judicial officer who imposed bail, but looking at the history of the case, I mean, there's, you're in custody for the probable cause hearing, and then you were released. You failed to appear for the arraignment. You were back in custody on another charge. So it seems like the only time
I did appear for the arraignment on the streets when for one of the causes. But like I said, they made it for like 3 days after my release. So then I went to it, and then it was 3 days after that they made another one, and I didn't have a phone or anything to be able to attend that one.
Okay, so how
But
about
I will not miss any other hearings. I promise you that. Like, this has been like the worst time I've ever done in jail. Like, I have nobody. I can't even use the phone. I can't talk to anybody. I have no way to contact anybody. I'm indigent. Your Honor, please, I'm begging you to just let me. I have multiple evidence in my case that I need to be able to go obtain on the streets, because I'm my own attorney, like I said, and I have nobody to do that for me.
Is there a reason why you don't want an attorney? I mean, this is work that an attorney could be doing for you.
Yeah, I know, but I've had bad experience with attorneys in the past, and I just, like, I've been researching all this myself, and I've just been taking care of it myself. I just need to be able to get out and get that information for you, Your Honor.
Okay, so do you have a phone number where the court can reach you and send text reminders of your court dates?
Yes.
Your Honor, I think Ms. Pritikin has made the state's position known, but I just want to reemphasize that there's been nothing to change any sort of consideration as when bail is imposed in these two cases. Superior Court, she's not being held in Superior Court. However, I've reviewed both reports, and the victim in the Superior Court case is the same as the victim in the protection order violation here, ending in 1023. And so if there were to be a change in conditions, the state's concerned, not only for general safety of the community, but also the victim in that case.
Okay. All right, thank you. Okay, were you receiving text reminders of your court dates on that number before?
Yes, but Matthew Davis stole my phone. So I have to get out and get a new phone, but yes, I can receive them on that phone.
And that's the victim in the protection order violation in the Superior Court case, Your Honor.
All right, and is Kinney Road? Is that a residential address for you, or a place where you can receive mail?
That's where I was receiving mail. Yes.
Is that an address you are?
I don't know if I'm allowed to be there. Like, that's where I live. He doesn't live there, but he keeps coming there and getting me arrested. Like, he lives on Lemon Road and I live on Kinney Road, but he comes there and gets me arrested. So how is that? I don't understand.
Well, if there's a protection order between the two of you.
Yeah, but how did he come to my house and get me arrested when he doesn't live there?
But that is part of how these orders work. Is you're not, and yeah. Again, I wasn't the judge.
Another change in circumstance. Like, he comes to my house and gets me arrested. You know, like, I promise, Your Honor, I will not speak with him anymore. I will not accept any calls or try to contact him at all. I'm begging you, please, just review these conditions or PR me, please. Like, this is, like I said, this is the worst time I've been in jail. I'm willing to do whatever I got to do to satisfy the court and work with the district attorney to resolve my cases. Please just give me this one more opportunity. And if I fail on this, like, I don't care how long you give me. I really don't.
And ma'am, if you can't go back to that address, where are you living? And is that a friend's house, or where does that?
Yes, that's my family's house.
Who lives there?
Brian Michael.
Okay. I mean, like, your relationship to them.
My cousin. And I can receive mail there.
All right. So since you're going to be staying in the area, okay, what I'm going to do is, so I'm going to release you, but I'm going to impose some heightened release conditions that require some pretrial services supervision.
Okay.
Because it seems to me that the biggest issue that I'm looking at is the failure to appear history, particularly in this case. And so I think we've got a new address for you. It is local. And so I think if there's a pretrial release requirement that keeps you in more constant communication with the court and requires you to check in, that will help I think that will help reduce the likelihood that you'll miss court. And that also On the other hand, though, that opens up more opportunities for bail to be reimposed, because if you start missing your check-ins with pretrial services, those are violation reports that the court could use to then reimpose bail.
Okay.
She believes going protects her control, but the court just laid out a compliance trap. Every missed call, missed check-in, or paperwork delay now becomes documented noncompliance. What feels like independence legally builds a record that justifies putting her back in custody.
So I am looking at the fact that that the Superior Court, subsequent to these charges, released you,
Yes.
and I think with some increased supervision from pretrial services, I think that might be a reasonable alternative here to.
Thank you so much,
bail
Your Honor.
So, all right. So what I'm going to do is on the matter ending in 1023. That's the protection order violation. I'm going to, I guess, not set bail in the amount of $5,000, but so I'll release you on your own recognizance there, but I'm going to impose as a condition of pretrial release, pretrial services supervision. So you'll get a copy of a judgment sentence order, ma'am, there at the jail.
Okay.
That has the phone number for pretrial services.
Okay.
Right? It says you have to contact them within 48 hours, and their phone number is right there on there. Okay, sounds
So
like
on Monday?
Yep.
Okay.
And so you'll need to spend the weekend making sure you get a good phone that you're able to utilize, because if they don't get that call from you, they're going to send in a violation report, and then you're going to have a lot of you're going to have a lot of failure to appears, and then failure to check in with pretrial services, and so you're looking at the possibility of more bail there. All right. So all other conditions remain the same, except for this pretrial services supervision requirement.
Okay.
You've got court dates already set. This was just set for a review hearing.
Yes.
Do you know your court dates?
Yes.
All right. So your next court date on all your cases is December 17th at 10 a.m. You're going to get this copy of this judgment sentence order that has your next court date on that as well. So you've got to have a hard copy of that.
Okay. Thank you.
Okay. All right. So no problem. So pretrial services supervision on that. And then on the matter ending in 6853, that's the DS3 and no ignition interlock device, in which you're held on $1,000. I'm just going to PR you on that. I'm not going to add any other conditions. That's going to just be on the one case.
Okay. Thank you so much, Your Honor.
All right. Yep. Good luck, ma'am.
Your Honor,
Thank
the last
you.
thing I think before Ms. Martini
And
leaves,
before you leave, yep.
Yeah.
Stick around here, ma'am.
as she is going to be representing herself on these cases, she'll need to receive discovery. My office was working a plan to get discovery to her in the jail. Now that she's being released, she'll need to go to district court and speak with the PAO office in building 2. So I don't know if she knows how to get there.
Yes.
Okay. Yeah. And man, so it sounds okay. You said yes. But I was also going to suggest that when you call pretrial services, maybe
You
just
can help
confirm,
me.
yeah, maybe just confirm then that you know where to go and
Okay.
all of that. Because you'll have to contact them on Monday. So that might be a good opportunity for you to just make sure you know where you're going to get discovery.
Thank you so much, Your Honor.
All right, not a problem. And I didn't sign the JNS. What was the time on the 17th again? 10 a.m. Okay. And you're free to be taken back there, ma'am.
Thank you.
Вот переписанный текст, примерно 1500 слов, с сохранением образовательного характера, структуры и экспертной подачи, но без избыточных повторов и с более плавной логикой изложения. Если вы давно на моем канале, то знаете, я не ограничиваюсь теорией. Мне важно не просто рассказать, а дать конкретные практические инструменты, которые вы действительно можете применять в своей интимной жизни. Те знания, которые помогают сделать близость более осознанной, более глубокой и приносящей удовольствие обоим партнерам. Сегодня я хочу разобрать тему, о которой меня часто спрашивают мужчины. Один из вопросов звучал так: «Доктор, расскажите про точку К». О точке G говорят много, но про точку К информации почти нет. Где она находится? Как ее стимулировать? И стоит ли вообще это делать? Действительно, вокруг женской анатомии и чувствительных зон существует много мифов. Кто-то до сих пор не уверен, где расположена точка G, как ее найти и как правильно воздействовать. Более того, при неправильной стимуляции можно не только не доставить удовольствия, но и вызвать дискомфорт или даже воспалительные процессы. Поэтому здесь крайне важны аккуратность, знание анатомии и уважение к телу партнерши. Начнем с основ. Если говорить о вульве и влагалище, то существует несколько зон, которые могут быть чувствительными. Наружная часть – это головка клитора, прикрытая капюшоном. Далее – ножки клитора, которые уходят глубже и располагаются внутри больших полостей.